a 5-bench panel of justices of the Appellate Division of the East African Court of Justice had the first and final submissions into an appeal seeking to have the case challenging the East African Crude Oil Pipeline project reinstated at a session held in Kigali, Rwanda. In 2023, the first instance division of the regional court dismissed the case filed by 4 civil society organizations on the ground that it was filed past the 2-month deadline. Article 30 of the East African Community Treaty dictates that legal proceedings should be instituted within 2 months from the period of an enactment, publication, or action complained of. It is this time frame that is a subject of contention, as the appellants argue that the signing of the intergovernmental agreement and host agreements were shrouded with confidentiality. The appellants argued that they learned of the signed agreements in 2020, yet according to the court documents tendered by the attorney generals from Uganda and Tanzania, the agreements were executed in 2017.
Because of the business secrets are confidential. They are not thrown around. Even now, they are not anywhere to be seen. So the applicant, who are private citizens organizations, have no way of knowing what happened in the corridors of power until there's a media publication.
I have a very strong fear that even the respondents at the level of their seniority, the government is not yet confident that they should give them those documents.
The governments of Uganda and Tanzania contended that the information the appellants filed in court proved that they were well aware of the signing of the agreements 2 years before they filed the petition.
The second appellant, which is Afiego, at a certain point in time, together with other organizations, appealed to the president of the African Development Bank challenging the EACOP project. So they knew of the project, and they started to challenge it in different forums, even before coming.
So very well knowing that, well, the information that I'm supposed to rely upon happened almost over 2 years ago. I'm therefore out of time under Article 30, Clause 2. You could as well honorably withdraw that statement of reference, because the timelines are very strict. Okay? The action took place in 2017.
Also before the appeal court is a prayer by the appellants for the court to set aside the costs that they were slapped with when the first instance court dismissed their case.
Court made a mistake to order the appellants to pay costs in a public interest case, which sought to vindicate the treaty of the South African Treaty. And basically we are saying there are good reasons as not to order the grant of the cost.
However, the respondents insisted that the court should maintain the costs.
But the Attorney General of Uganda is even requesting that the people pay costs to the government, because you are the government. So those people sitting behind you are saying they should pay costs to the government of Uganda.
Who has paid you? Who is paying you? You and your team. Isn't it the same people? They give you salary. Now you say again they should pay you for... Where do you get the basis of your claim?
Definitely, with every appropriation comes priorities. Now, what we have here is a case which shouldn't have been a priority. That is the contention. On account of the information that the government has availed the appellants. What that means is that the case then becomes frivolous and vexatious. And it's our contention that the appellants should have been honorable enough to withdraw.
The appellants will for now keep their fingers crossed, hoping that the appeals division of the regional court will find their reasoning compelling enough to warrant reinstatement of the case for its 12 merits to be heard. The judgment day will be communicated. I'm Jackson Onyango, reporting for NTV in Kigali, Rwanda.